Good day. I'm Vannessa Nicholas, the Head of Estates and Administration at Appleton Fiduciary Services. Today I'd like to speak to you about whether or not it's necessary to have a local will, international will, or both. In order to answer the question as to whether or not we need to have a local will, an international will, or both, we need to look at the nature and type of asset, as well as the location and jurisdiction of that asset. These factors will determine whether or not you do need an international will, a local will, or both. Let's firstly look at the type or nature of the offshore investment. Should the asset consist of an investment which is held offshore but administered through a South African institution, then it's not necessary to have an international will, as the South African will and the South African executor will be able to deal with that asset. If the only offshore asset is a bank account or an investment, then the local will should be suffice. However, this will must refer to as being your worldwide will. One must bear in mind the principle of survivorship. The survivorship rule basically means if an asset is jointly owned by two parties, when one party passes away, the other party will automatically take full ownership of the investment or bank account. This survivorship rule normally applies to assets held in the UK, the Channel Isles, that's Guernsey, and the Isle of Man, and sometimes Mauritius as well. Fixed assets pose more of an issue due to the jurisdiction and basically where these assets are located. It would be best to seek the legal advice of somebody in that country where the property is located, as they will be able to guide you in respect of inheritance law for that particular country and how that asset is to be dealt with. So moving on to jurisdiction and location, we've just touched on that briefly with speaking about a fixed property. One must remember that in South Africa, one has the freedom of testation. Basically, what that means is that you can bequeath your assets freely. In certain other countries, there is, however, no freedom of testation, and it's not recognized. While we in South Africa have a freedom of testation, you can bequeath your assets freely, whilst in some countries, freedom of testation is not permitted and not recognized. Therefore, countries have inheritance laws that, despite how you would like to leave your assets, it actually does not work that way. So, for instance, Portugal, France, Japan, Switzerland, perhaps also then countries that are governed with Sharia law. So basically what they mean by freedom of testation is, again, freedom in South Africa. We are free to distribute our assets as we like, while in turn the term that is used, forced heirship, is what is used in certain other countries. Basically, there are certain limitations. Normally what would happen then is that you would have to leave a certain percentage of your part of your estate to a child or a spouse, or depending on exactly what the rules of that particular country is. Okay, so that should you own assets in a country where there is forced heirship again, meaning the legal principle that mandates as how one leaves their estate. We would suggest that you do draft a separate will in respect of those assets held in that particular country. So taking what we have just chatted about into consideration, the options available would be to draft one will dealing with worldwide all of your assets, your South African assets as well as your international assets. Basically, your will state, this is my worldwide will. Alternatively, drafting a will, a separate will in terms of where assets are held. So you would perhaps have a will in France dealing with your property held in France, a will in Mauritius should you have a property in Mauritius. Thirdly, perhaps is to draft separate wills basically you have one will which deals with only your South African assets, and then a further will dealing with your offshore assets. One must just be very clear that your wills do stipulate my wills in South Africa for your local will, and then for your international, my assets that are owned internationally. Should one have more than one will, one must just make sure that one doesn't end up revoking your will in terms of your second will or your third will dealing with your offshore assets. So to be very specific in respect of your will, that this is the will that deals with my South African assets, and this is the will that deals with my international assets. And when revoking one, you are only revoking the one dealing with your South African assets or the one dealing with your international assets, as you don't want a situation where you are revoking both of your assets, or at the end of the day, then you have no valid will. I hope you found this short discussion interesting. And if you have any queries, please contact Appleton Fiduciary Services on 0800 50 60 70, or alternatively, you can email us on clientcare@appleton.com. Thank you.